Good morning, ladies and gentlemen. This is your host, Elgin Martinez from the Immigrant Edification TV, coming to you with another informative video. The video this morning is going to be about the 8 steps required to file a divorce in the state of New York. That being said, all divorces in New York State are granted by the Supreme Court of New York. The steps in getting a divorce in the state of New York will depend on whether the divorce is contested or uncontested, and also if there are any minor children or property disputes involved. Step 1, ladies and gentlemen, ensure that you meet the residency requirement to file for divorce in New York State. Step 2, contact the county clerk's office in your county and request an uncontested divorce package. Step 3, fill out the forms in the package. There are 14 forms in the package. Prepare 3 copies of the summons with notice form. The summons is a legal document that begins the divorce proceedings. It states the reason you are requesting the divorce and includes any requests for child support, maintenance, custody, or property settlement. Step number 4, purchase an index number at the county clerk office. An index number is about $210. The index number is used to identify a case in the New York Supreme Court. If you can't afford the index number fees, you can file a poor person application in the clerk's office requesting a waiver of the index fee. Once you've gotten the index number, file the summons and the verified complaint form from your package with the county clerk. Step 5, arrange for someone over the age of 18 who is not involved in the divorce to deliver a copy of the summons, the verified complaint, notice of automatic orders, and the notice concerning continuation of health care coverage form to your spouse. This must be done within 120 days of purchasing of the index number. The person should also deliver a copy of the affidavit of defendant, which the spouse will need to sign and return to the defendant. If you have any children under 21 years old, you will need to serve a copy of the child support standards charged to your spouse. Step 6, the defendant should be served a copy of the sworn statement of removal of barriers to remarriage form. If you were married in a religious ceremony. If you were married in a civil ceremony, you do not need to do this. If your spouse does not return the affidavit of defendant to the court or returns the form and states that he does not agree to the divorce, then your divorce becomes a contested divorce. Should something like this happen, ladies and gentlemen, then your best option would be to go consult with an attorney. Step number 7, if your divorce is uncontested, that is, if your spouse or defendant has agreed to the terms of the divorce by signing the affidavit of defendant form, you may request your case to be placed on the calendar immediately. If your divorce is contested, you will need to wait 120 days to put it on the calendar. Step number 8, complete the request for judicial intervention form and the certificate of dissolution of marriage form, and if needed, the divorce and child support summary form. Fill these forms along with a copy of the summons, note of issue, and the verified complaint with the county clerk's office. You will also need to pay a filing fee unless you have been granted a waiver. The papers will then be submitted to a judge. If the papers are all in order, the judge will issue a judgment of divorce. If your divorce is contested, you will be given a date for a court hearing in front of a judge. The judge will then decide the terms of your divorce settlement. Ladies and gentlemen, sadly we've come to the end of this video. Please share, like, subscribe, and hit the notification bell.